for my result. Oh my god, I got first class. So I don't have to pay for PTPTN. I got first class, so I need to write a letter to PTPTN so I can get exemption from paying PTPTN. Oh, you got a letter? Letter for me? Yes. What is it? From PTPTN? Do I still have to pay for it? But I got first class. I think you should go to the court. Oh, really? Yes.
The appellant graduated from University of London Bachelor of Laws at a local private institution of higher learning in 2002. On 5 August 2003, the appellant applied for an exemption from repaying her study loans based on a 2003 circular from the Perbadanan Tabung Pendidikan Tinggi Nasional (PTPTN), as she had obtained a first-class honours in her bachelor degree. 3 years later, the appellant received a letter from the respondent requesting for repayment of her loans. The request was based on the fact that the appellant did not produce a copy of the certificate of accreditation for the LLB course that she attended. Thus, the respondent could not process her application. The respondent then obtained a judgment in default from the Sessions Court against the appellant for her failure to repay the loans, which prevented the appellant from leaving the country as per Section 22A of the Perbadanan Tabung Pendidikan Tinggi Nasional Act 1997 at 566. The appellant then sought leave to file for a judicial review in the High Court on the ground that the respondent had acted without its jurisdiction as follows. The rejection of the appellant appeared despite the appellant having obtained the degree of laws with first-class honours, the imposition or interpretation of a condition which contradicted its own action, and the imposition of the additional condition and or requirement to prevent the appellant from benefiting from the exemption for repayment provision under the 2003 circular. The leave were refused by the High Court on the ground that the High Court would not be in a position to decide on the appropriateness or adequacy of any particular policy by the government. The appellant then applied to the Court of Appeal.
The law applicable in this case is Section 22A PTPTN Act 1997, Order 53 of Rules of Court 2012, Order 53 R3 Clause 3, Order 53 R8, Section 19 and Section 49 of PTPTN Act, Order 53 of the ROC 2012, O53 RAC, 53 R8 of ROC 2012, Order 53 R8 Clause 1, S2 of the Lembaga Akreditasi Negara Act 1996, and Section 49 Clause 1 of PTPTN Act.
We also agreed that the court should interpret the words of the circular clearly and literally. The condition is for a credit course, not for the existence of accreditation throughout her studies. Further, Mr. Tay agreed that focusing on the accreditation did create an unfair and illogical situation. Ignoring her academic achievement, the purpose of this policy is to reward outstanding graduates. Mr. Tay finally obtained a certificate proving the program's accreditation, further strengthening her position. This agreement's success in convincing the Court of Appeal to rule in his favour. The court preferred the circular wording and spirit of the policy to recognise academic rather than technical excellence regarding the date of accreditation. This agreement's success in convincing the Court of Appeal to rule in her favour. The court preferred the circular wording and spirit of the policy to recognise academic rather than technical excellence regarding the date of accreditation.
The respondent in this case, which is Perbadanan Tabung Pendidikan Tinggi Nasional, put forth a legal argument centered around several key points. Firstly, they contended that the decision being challenged by the appellant was a policy decision, emphasizing that the court should not intervene in matters related to government policies. Secondly, the respondent argued that the appellant, which is mistake, was not challenging the policy itself, but rather its implementation by the PTPTN. They maintained that the rejection of the appellant's application for exemption was based on the interpretation and application of the policy, not the policy decision itself. Lastly, the respondent asserted that they act within their jurisdiction in rejecting the appellant application exemption, citing the specific criteria outlined in the policy. Overall, their legal argument aimed to justify their decision and emphasize that it was not tainted with illegality, irrationality, or procedural impropriety warranting judicial intervention.
Next, I will talk about the decision that have been given in this case.
In summary, the Court of Appeal ruled in favor of Teck Guat Hong, emphasizing that the course accreditation was the key factor for loan exemption, regardless of the timing of the certificate. This decision clarified the eligibility criteria for PTPTN loan exemption based on academic achievement. For the court decision, PTPTN's argument was dismissed by the Court of Appeal. They focus on the phrase kursus yang mendapat sijil perakuan akreditasi, taking the circular's wording literally. The court decided the accreditation need only apply to the course in question, which is and not to the whole time the student was enrolled. It would be unjust and ridiculous to insist on the date of accreditation.
Of the legal argument presented by the respondents in the case of Teck Guat Hong vs Perbadanan Tabung Pendidikan Tinggi Nasional, we can refer to the following case law. First, like Michael J. Joseph vs the Minister of Education, Ministry of Education Malaysia in 2012, which is, this case established the principle that court should refrain from intervening in policy decision of the governments and should not assess the appropriateness or adequacy of such policies. The respondents' decisions to eliminate the PPSMI was not subject to judicial review and was therefore not justiciable. The applicant lacked the legal authority to compel the respondents to carry out the PPSMI implementation in the state of Sabah because the decision to abolish the program was obviously a policy decision made by the governments based on the respondents' exercise of a function as Minister of Education. Therefore, the leave request was baseless and unsubstantiated. The second case law is Dr. Michael J. Kumar Devaraj vs Peguam Negara Malaysia in 2013. This case further support the notion that decisions involving policy consideration are generally not amenable to judicial review. The appellant request for leave was granted by the High Court judge. However, the High Court ruling was overturned by the Court of Appeal after an appeal. The appellant challenge was deemed legally unsustainable and consequently not subject to judicial review by the Court of Appeal, which concluded that the special constituency allocation required policy deliberation and management authority. The appellant failed and appeal in this case challenges the Court of Appeal ruling. The third case law is Merdeka University Berhad vs Government of Malaysia in 1981. This case provides precedence for the principle that court should exercise caution when reviewing government's policies and decisions, especially when they involve policy consideration. A writ was filed by the plaintiff seeking a declaration that the Federal Constitution was violated by the rejections of the petition to establish
Merdeka University, and the refusal of the petition was an improper and unreasonable use of the discretion granted by the Section 6 of the Universities and Universities Colleges Act 1971.
Hey Mimi. Hey. Hi. Do you know that I won the case?
Oh,
The court decision was I don't have to pay for the PTPTN.
OMG! Congratulations!
Great, right?
Yes.
Thank you.
Welcome.